Firstly, I would like to acknowledge that we meet today on Whadjuk Noongar land and to acknowledge the Whadjuk Noongar people as the original owners and spiritual custodians of this country. Talking aloud. Talking aloud was an idea which came about when Clarissa Ball, who's the director of the Institute of Advanced Studies, and myself were musing over how do we get people together to talk about really interesting current ideas, but of course with a focus on the arts, which is where our interests lie. So Talking Aloud is just that. It's a forum in which we will all have the opportunity to discuss a particularly important current issue, but through the lens of the arts. And today we're extremely lucky to have our wonderful speaker, Jani McCutcheon from the School of Law, who's an expert in matters legal, ethical and related to copyright and intellectual property. And she's going to be talking about a very current issue, the 18C legislation and the impact of an image that I'm sure is always burned into your retina that was made by Bill Leak and sadly became such an issue when he died recently. So without further ado, please welcome Jani McCutcheon.
Thank you. Thank you. Thank you very much, Ted, and thank you very much for all of you for coming today and for inviting me to speak today, particularly at this inaugural Talking Aloud session, which places a great burden on my shoulders, but I'll try and do the best I can. I certainly look forward to coming and participating in many future events as well. I think it's a fantastic initiative. Okay, I'm going to try and use this bit of technology without being silly. There we go. Oh, does that look all right to you? Okay, that should be familiar to you. To me it looks kind of blurry. Does it look kind of blurry to you? It wasn't blurry on my PowerPoint slides, but you know. But just tell us the text. Yes, I'll try and it's very small here, but well, sorry, this is my eyes. Yeah. Have to sit down and talk to your son about, responsibility. And the father says, yeah, righto, what's his name then? So this was the cartoon, which is referenced in the title of this talk that I'm giving today. It's certainly a potent impetus for a discussion about the relationship between art and law and freedom of expression, which is the broad topic that I'm addressing today. I am going to speak a bit about Leak's cartoon, but I hope that then I'm going to lead that into a broader discussion about how the law interfaces with artistic expression in particular. But I think, as Ted mentioned, it's made all the more poignant, of course, by Bill Leak's recent passing, and I personally couldn't help but think, I wonder how much this all had to do with what befell poor Bill Leak. For those of you that have been living under a rock, Bill Leak was accused of breaching Section 18C of the Racial Discrimination Act. Now, I'm actually not going to revisit the debate about what the cartoon constituted, in particular whether it was, as some argued, a refreshing antidote to the haze of political correctness, or as others argued, was just a racist, hateful smear. There was enough ventilation of those opposing views in the press, and I think we all are suffering a little bit from 18C fatigue anyway, so there's some things I'm not going to revisit. I'm also not going to debate the appropriate wording of 18C because that has been done to death. Let's say that Bill Leak certainly had firm views about how the case should have been determined had it run its course, and this is part of his submission to the Parliamentary Joint Committee into Section 18C of the Racial Discrimination Act, which you might remember was the sort of inconclusive determination about whether the wording should change, and then the government introduced its bill. Was the complaint frivolous? Was Bill Leak correct? We'll never really know because the complaint was actually withdrawn, so it was never actually tested, and we don't know whether or not his cartoon would have been captured by the wording of Section 18C. But what I'm really interested in teasing out a little bit more today is the counterpoint to Section 18C, which I think was actually overlooked quite significantly in some of the debate about surrounding this. I think there was a lot of focus on 18C and whether the cartoon constituted a breach of that, and less focus on 18D, which is the balancing act that was necessary when 18C was introduced. So there's a few people that have suggested that had the complaint run its course, Section 18D would have come in and protected leak from liability. So I'm in particular interested in the words that I've highlighted in Section 18D, which are that it exempts conduct or an act which otherwise might be caught by Section 18C, but which was done reasonably in good faith in the performance, exhibition or distribution of an artistic work. So, of course, this raises the issue of what is an artistic work, why in particular is art insulated under Section 18D, and I think that raises some really interesting questions about almost the reification of art that some laws actually embrace. So what is an artistic work, and in particular was Bill Leak's cartoon an artistic work? There's quite a bit of debate actually in the artistic fraternity or community about whether or not cartoons constitute artistic works. Again, that's a little bit blurry, but you can get the gist of that, I think. Actually, this was not the first time that this issue has been ventilated. We actually have a local example, a fairly famous local example. Some of you in the audience might remember this. This was late 1990s. Dean Alston published this cartoon in the West Australian, and it was alleged to infringe 18C. Again, that's a little bit blurry, but I'm not going to go into the details again of the context of the cartoon or whether it might have breached Section 18C. Basically, this concerned the repatriation from England of the remains of a Noongar warrior who resisted the European settlement of Western Australia, and in 1833, for his troubles, he was shot by a settler and his head was removed from his body and was sent to the United Kingdom for display in a museum. Was eventually put into an unmarked grave, and in the early 90s there was a movement to return those remains. This went to court ultimately. A complaint was lodged in response to Alston's cartoon with the Human Rights Commission under 18C. And I'm just quoting now from the full Court of the Federal Court decision, because the organisation of the handover of the remains was, quote, accompanied by a degree of sometimes undignified acrimony over who had the appropriate cultural claims by descent to bring the remains back. Now, in this cartoon, Alston referenced that conflict, which had been very broadly and publicly aired before the cartoon was published. So we have the complaint was dismissed by the Commissioner of the Human Rights Commission under the artistic works exemption. That was upheld on appeal to a single judge of the Federal Court, and it was upheld again on appeal to the full Court of the Federal Court. And the full Court of the Federal Court made some comments about the meaning of artistic work in Section 18D. First comment was that the term seems to be used broadly in Section 18D, and the Justice French, as he then was, said it includes works in both the visual and performing arts, and it probably includes literary works as well. So that does, to me, seem to be a very broad definition of artistic work. We might not think of literary works, for example, ordinarily as artistic works. We might think of them as a member of the arts, but not necessarily artistic works. And as a copyright scholar, of course, I immediately thought of the term artistic work, which is used in the Copyright Act, which is strictly limited to works of visual art. So the result, if we take this capacious, approach to the meaning of artistic work, which seems to be what the full Federal Court had in mind, seems to be that, I'll try and go back to the slide here, that really the heavy work under Section 18D is probably done by those first highlighted words, reasonably and in good faith. And then I started thinking, well, that's really interesting in the context of art, particularly the word reasonableness, because we don't usually think of art as being particularly reasonable. We don't think of artists as necessarily rational creatures. We have philosophers going back millennia talking about, artistic creation being a kind of a madness. So its irrationality is pretty well known. Günter Grass, for example, said Art is so wonderfully irrational, exuberantly pointless, but necessary all the same. Pointless and yet necessary. That's hard for a Puritan to understand. And the relevance of this term reasonably and in good faith, at least in the artistic work exemption provision, was questioned by at least one Member of Parliament during the very lengthy debate over Section 18C, which just took place in the Senate. And I'm quoting, "What is the test for reasonable? What is the test for good faith? It simply should be, if it's an artistic work, as in the Bill Leak case, exempt from the Act. The defence for Bill Leak's cartoon simply should be, it's a bloody cartoon." Unquote. So that's the reasonableness bit, and I agree. I think it's sort of a bit ambiguous and it's a bit odd in the context of an artistic work exemption. Maybe good faith is a bit different though. So for me, that might conjure up notions, for example, of artistic honesty and integrity, and when you're engaging in the work, that you're engaging it for the sake of artistic expression genuinely and honestly, as opposed to some ulterior motive. So that could perhaps be co-opted as a useful mechanism in the provision. So, where was I? So, the other thing that this all gets you thinking about is this notion of cartoons and the power of the cartoon. What is it with cartoons that provoke so much violent, drastic, radical responses? And of course, I'm thinking of the murders of 5 cartoonists in January 2015 at the offices of Charlie Hebdo. And I'm thinking of Syrian cartoonists who have had their hands broken for creating cartoons that are critical of Assad. I'm thinking of throwing countless cartoonists in jail, and I can tell you would not want to be a journalist or a cartoonist in Turkey at the moment, because there's almost 200 of them sitting in jail at the moment and have been for a long time. So I got thinking about this. Well, what is it about cartoons? They're very immediate. They're much easier to understand than art per se. They're often, let's be honest, created for the sake of provocation. Certainly Leak's cartoon was deliberately created for that purpose. We have the dual meanings of text and graphic expression in a cartoon, which do work together and catalyse in a way that is a holistic, that gives you a holistic understanding of the hybrid text graphic kind of expression there. And I think they're more dangerous than art because of their directness. And art it's certainly speech, and it certainly can deliver a message, but it has a different narrative, I think, to cartoons. It's delivered by the art itself. There's no text that's aligned with the artistic work. And art, of course, notoriously has a variability of meaning. There's a much greater subjectivity of interpretation when it comes to art than with cartoons. So we have much more of an ambiguous, nuanced, kind of even muted message that's delivered by art. Of course, in Bill Leak's case, that cartoon was very direct. The meaning was quite deliberately confined and very overt, and it was correspondingly far less open to interpretation. And therefore, that's probably, you don't have people taking to the streets about, for example, an abstract artwork on a wall. You tend to have people taking to the streets about these kinds of very clear, powerful, and ultimately potentially offensive messages. So that also got me thinking, well, why is art singled out for special protection under not only the Racial Discrimination Act, but there are a number of criminal provisions where there's an effective defence if you show that the work has artistic merit, for example, in the case of obscenity charges in particular. It seemed to me that it's because we regard freedom of speech as an essential human right. Freedom of speech is indeed an essential human right, and you'll see from the wording of Article 19.2 that art gets a particular singled out special mention. So it's for reasons like this, articulated in the UN report on the right to artistic expression and creation, that we're not only interested in protecting the right of artists to engage in free artistic expression in and of itself. We do that with a communal benefit in mind. It's because of what artists do that communities benefit. So the public benefit of art is embedded in this notion of artistic expression being an essential human right. So its social and cultural value is integral to humanity at the end of the day. And of course, even if it's offensive, even if it's difficult to hear, difficult to see, uncomfortable, and so that brings us to that famous quote from Voltaire, which is no doubt overquoted, and I'm going to add to the overquoting. So even if we're disgusted or offended, if we hate what an artist is saying, as a lot of people hated what Bill Leak said, we have to uphold the right at least to express it, because we don't even have the conversation if we don't have the expression. So it is integral. Okay, I now want to spend a little bit of time about just looking at how else law regulates artistic expression, and these are just initial thoughts of mine. There's probably a longer list that's available, but there's lots of ways in which the law impacts directly on artistic freedom of expression. I'm not going to go through examples of all of them, otherwise we'd be here all afternoon. But certainly obscenity, blasphemy not so much, but obscenity, sexually explicit material, probably most reported cases of the conflict between artistic expression and the law tend to generate in this area. Even from 1907, we've got Norman Lindsay's work being turned to the wall. We've got Juan de Villa, 1982 Biennale. That was seized by the police, but good old Neville Rand stepped in and said, slow down here. This is really not what should be happening here. The Vice Squad, go away. And then, of course, the Henson Affair. The Henson Affair, for those of you that don't remember, in May 2008, the Rosalind Oxley Gallery was exhibiting about 40 works of Henson. It was a major exhibition. At the time, there was mention in Miranda Devine's article, the invitation that was sent out, which included an image which ultimately was seized by police, who gave a statement saying, "We have seized some items depicting a child under the age of 16 years in a sexual context." And this was the image, for those of you that didn't see it. And here are some responses. So this is David Marr's book that he wrote following the case. He's always incredibly prolific, David Marr, and he seems to put the book out in about 2 weeks after it's all happened. And he did that again. He writes very beautifully of a very beautiful image. Halo of light, self-absorption, entirely beautiful, modestly obscured by her hands in deep shadow. That's, one view of the image. Here are some other views of the image. Revolting, unacceptable, sickening, disgusting. Hetty Johnson, by the way, was the one who really galvanised the police into action and got them going. Now, in the end, our Kate Blanchett came to the rescue and got a whole bunch of artists to write a letter saying, back off, don't be ridiculous, don't be embarrassing. And also there was a very clever strategy that was undertaken by Henson, who got the image classified by the Classification Board. It was classified PG. At the time, Harry Potter and the Prisoner of Azkaban was M15+. So that kind of puts it in context for you. Another very controversial case from 2014 was Paul Yor's work. This was a Melbourne exhibition. The charges were laid and he was prosecuted for producing and possessing child pornography. It was a riotous, this was actually almost like a cubby house that you could walk through. It was riotous, it was cacophonous, it had all sorts of pop culture references, lots of references to consumerism. And yes, there were dildos in there and there were pictures of children's faces pasted over the heads of adult male bodies in naked or near-naked poses with Pokemon stickers over the genitals. Okay, so these were the problem pictures. This was the child pornography. What was really interesting about this case was the police going in with their search warrant and physically cutting out with a box cutter the offending images, which one would have thought wasn't strictly necessary. Anyway, the charges were ultimately dismissed. Again, quite clever, got the most offending image, the one that the magistrate said could arguably have constituted child pornography, as defined. That was rated as well. It was an 18+ rating, so all it needed was a warning, a suitable warning, and restricted viewing by people over 18. And of course, the magistrate said, look, some people are going to be completely disgusted by this. Some people are going to find it a very interesting exploration of sexuality, queer sexuality, consumerism, and whatever else you might interpret it as communicating about. Then intellectual property rights. Sorry, we probably shouldn't, I don't know, maybe make this smaller, but you can see that on the left, you won't be able to see it very clearly, but for those of you that can spot a Louis Vuitton trademark on that handbag of that obviously malnourished African child, this was Nadia Plesner's, and again, we've missed her, but the artist was Nadia Plesner. The image was called Simple Living. It was clearly a pun on an American TV show which had Nicole Richie in it and Paris Hilton, and I forget the name of it, but they pretended to be poor for a while, and Paris Hilton loved a Chihuahua apparently, and she loved a Louis Vuitton bag. This was obviously Nadia Plesner making a comment about the obscenity of this kind of consumerism relative to poverty and starvation. Interestingly, Louis Vuitton sued in Europe under its registered design rights over the symbol that was depicted in the bag. Initially won, she appealed and ultimately won on human rights grounds. So her right to freedom of expression trumped the property rights of Louis Vuitton. On the right we have a photographer who took a photo of 9 German Shepherd puppies and a couple. We have Jeff Koons appropriating that image. Jeff Koons is an appropriation machine. He's very good at that. He's made a lot of money out of it. And he's consistently sued for it, sometimes successfully, sometimes not. This was a successful action against Jeff Koons for infringing the copyright in the photograph. So intellectual property rights can sometimes be useful at stamping out artistic expression. Then we have the aptly named Sensation exhibition. That was a highly, notoriously provocative exhibition in the late 1990s. Artworks were consistently vandalised, there were lots of protests, people resigned, it was chaotic and very controversial. New York's Catholic Mayor Rudy Giuliani threatened to defund the exhibiting museum when it toured to New York. And a similar threat of defunding was made in this instance. So contract is actually a pretty powerful tool for regulating artistic expression as well, and one that we might not think of as being powerful, but it is. So in this instance, we've got Mark Ryden's works, which show, well, the one on the right in particular called Rosie's Tea Party, you won't be able to see this from the image, but she's carving up a ham which is inscribed with the Latin words which translate to body of Christ. So this was blasphemous. And a Christian local councillor threatened to defund the local museum that was exhibiting this work, or these works, as a result of this. So funding, what's that got to do with contract? Well, funding comes through contracts. And contracts are binding agreements between 2 or more people, and you have to do what you have promised to do. And you can be made to promise to do all sorts of things if you don't have very strong bargaining power, which is usually the case with artists. So increasingly, artists are asked to sign indemnities in commissioning contracts, promising that they won't, offend any law or breach any law. and that if something happens whereby, you know, they're sued, or the gallery or the commissioner is sued, that they will indemnify the gallery or the commissioner for any loss that's suffered as a result of that. So when you tie contract terms in this way to, you know, it does impact on the kind of expression that's possible. Defamation is another civil action that can restrain creative expression. Lots of cases of defamatory cartoons in particular, because of the reasons that I articulated earlier, that the imputations that are necessary to establish in defamation actions are easier to extract from the textual component of a cartoon in concert with the graphic elements. But you know, you clearly get the message from this one as well. You don't need any words. So this is a Polish-born American artist who had an encounter with Justice Jeffrey Altbach in the very aptly named town of Liberty Town in America. I'm not making that up. The case didn't go so well for the artist, and to express his displeasure, he painted this lovely portrait of the judge, and he was offering it for sale and exhibiting it. The judge sued for defamation, seeking $1.5 million in damages. I don't know what he thinks the average income of an artist is, but good luck. He said that this was defamatory, and ultimately the judge ruled sensibly, and of course, as the judge would have had to have ruled, that the painting simply represented the opinion of the artist, and it could not reasonably be understood as a factual assertion that the judge was in fact the devil. So that was okay. And then, of course, we've got not only to fight human censors, but we now have to fight robot censors as well. So these are, you know, programs that are basically trained to trawl through. You probably even encountered it. Not only does it pick up intellectual property, you know, that you've got on your Facebook post with your kid dancing to a copyrighted song or whatever, but allegedly obscene images and pornographic images are now regularly, you know, you've probably heard about the controversy of, you know, the breast cancer images, you know, being shut down by Facebook and all that sort of stuff. And then, of course, outside the law, we have other calls for censorship. This is an ongoing issue across all of the arts, literature and the visual arts. Basically calls for censorship that are based on notions of unjust appropriation of minorities' subject matter or minorities' voices. Now, there's no law that actually prohibits this, at least that I'm aware of, but there's plenty of offence when it happens, and there's censorious pressure to stop doing it or to not do it at all. So this is happening as we speak. This is only weeks old, this controversy. There's a white artist called Dana Schutz who painted her interpretation of an iconic image from the 1950s of the open casket of a very poor black teenage boy called Emmett Till, who you may have heard of. He was apparently flirted with a white woman and was found dead 3 days later, having been brutally murdered. His eye was shot, his head was caved in, and he was left in the river for 3 days by two white supremacists, and it was shocking because they got off scot-free despite later on admitting to the murder. And to make it even worse, the white woman, only about, I think, 8 years ago, confessed that, in fact, he had never flirted with her. Anyway, Emmett's mother demanded that the body be returned to her in Chicago. He was in the South at the time this happened, visiting relatives. The Southern authorities wanted to bury the body immediately, but she insisted that it be returned to her, and very bravely, she had an open casket at the funeral, and she allowed members of the black press to take photographs of his seriously disfigured face. And that photograph became an icon of the civil rights movement, basically a very galvanising force. Dana Schutz appropriated the image, let's be honest. It's an abstract version of the photograph. It's her interpretation of that, and it has wreaked havoc. Basically, we have the black community, well, members of the black community, not all of them, members of the black community, this guy is standing in front of a Black Death spectacle, so he silently protested in front of the image. We had calls for the image to be removed from the exhibition and destroyed. Quite a strong call for the ultimate act of censorship, destruction of the work. Why? Basically because the artist is a white woman and the subject matter is not hers to utilise. So I just wanted to mention that because, you know, even outside the law, there is a very strong regulatory force. I think Bill Leake kind of sums it up nicely. It's an aspect of self-censorship, and it's also an aspect of what I kind of call soft censorship. So not hard law censoring this, but the stronger force in many respects than the law that we find in a statute book or in a judgment is in fact the law of moral righteousness and outrage. So it's public animosity to messages that cause discomfort or offence or outrage, and the accommodation of that animosity that has a very profound regulating effect, and as I go much more so often than the law itself. So this leads to exhibitions being dismantled, websites being taken down, portions of books being redacted, funding bodies withdrawing or diminishing funding for both artists and the spaces that they need to do their work, insurers withdrawing protection from galleries and artists, publishers and galleries deciding not to take the risk. And none of this is legally directed, but it operates in the shadow of the law. So the potential of legal risk results in this insidious restraint of this kind of soft censorship, this artistic self-censorship as well. And self-censorship is particularly pernicious because it's impossible to measure or quantify its effects, because it's non-action. You know, it's a void, and you can't actually measure a void. So it's this possibility of expression which is snuffed out. And it has to mean that we must surely have a diminished creative experience as a result of that. You know, how many art pieces will not be made and will not be seen? How many cartoons will never be created? Who will be the next Bill Leake? Will there be a next Bill Leake? You know, so the cumulative effect of all this clearly will be reflected in the content and diversity of artistic expression that's available to the public. But I think the legacy of this kind of soft self-regulation is probably homogenised art, you know, more of the same, complacency, insularity, reproduction rather than new production, repression rather than expression, silence and saccharine repetition as opposed to shock and innovation and confrontation. So, concluding thoughts, I'm going to appropriate the thoughts of another person, Salman Rushdie, who in his Arthur Miller Freedom to Write lecture in 2012 said, "Why are artists so troublesome? Can't they just offer us beauty, morality and a damn good story? Great art, or let's just say more modestly, original art, is never created in the safe middle ground, but always at the edge. Originality is dangerous. It challenges, questions, overturns assumptions, unsettles moral codes, disrespects sacred cows or other such entities. It can be shocking or ugly, or to use the catch-all term so beloved of the tabloid press, controversial. Art is not entertainment. At its very best, it's a revolution." And those are Salman Rushdie's concluding thoughts. Thank you very much for your time.